Right, hello, Vikings. We are on Unit 3, Civil Rights and Civil Liberties. So this is part 4 of my video series on this. If you want to check out parts 1, 2, and 3, where I kind of explain the tests, go over Unit 1 and go over Unit 2. Those are in 3 separate videos. So let's jump into the curriculum right now. Through the U.S. Constitution, but primarily through the Bill of Rights and the 14th Amendment, citizens and groups have attempted to restrict national and state governments from unduly infringing upon individual rights essential to ordered liberty and from denying equal protection under the law. Likewise, it has sometimes been argued that these legal protections have been used to block reforms and restrict freedoms of others in the name of social order. So this is the idea of the balance in the debate. How many rules are too many rules? How many laws are too many laws? And when is a law okay because it's in the name of public safety? And when is a law not okay because it's just designed to, hurt the rights of women or hurt the rights of a minority group or, LGBTQ, that kinds of stuff. So it's a balance basically, and people have different opinions on that. And definitely sometimes you'd say, okay, that law is good and that's necessary for public safety, or, oh, that law is not good. That doesn't help public safety. That's just trying to prevent criticism of the government, or that's just trying to, just take away our rights or take away our liberties basically. All right. The Constitution, but especially the Bill of Rights and the 14th Amendment, are used to assert the rights of citizens and protect groups from discrimination. As such, the government must respect the dignity of the person and assure equal treatment with its power constrained in the process of protecting individual freedoms. The 14th Amendment includes 2 clauses that affirm and protect civil rights and liberties, the Due Process Clause and the Equal Protection Clause. So due process is just the idea that we all need to have the same fair process, and no matter what my race, my gender is, I should get the same legal process and the same legal protections as everybody else. And then equal protection is basically that I should be treated the same under the law. We shouldn't have a law that's only for this race or only for this gender. That's not fair. That's not right. The courts must balance the desire for social order with the protection of individual rights and freedoms when considering the due process and equal protection challenges. Again, it is okay to restrict sometimes because it's in the name of social order and that kinds of stuff, but not, just for a racist basis or something like that. In a process known as selective incorporation, the Supreme Court has used the power of judicial review to interpret the Due Process Clause in such a way as to prevent states from unduly restricting fundamental freedoms. The court has been called upon to interpret protections for freedom of political expression and religious exercise. That's First Amendment. The right to bear arms and the right of privacy. Bear arms is Second Amendment. Privacy is not in a specific numbered amendment. It is one of those kind of informal powers that came out of a Supreme Court case. And the rights necessary to ensure that those accused of crimes receive a fair trial. So those protections are both in your Fifth and then also your Sixth Amendment rights. The Equal Protection Clause provides that states may not deprive persons of equal protection under the law. African Americans, Hispanics, women, LGBTQ people, and other groups have used the clause to lead social movements on behalf of their concern. So that clause in the Constitution, when people go and protest, and all these groups, different groups have protests, they've used that language of the 14th Amendment to say, this is why I should have the right. You're not respecting the language of the Constitution. And so let me use it and show you why you need to treat me equally and why I should have the same exact rights. It doesn't matter who I choose to marry. It doesn't matter who what race I am, that I was born, that kinds of stuff. That kind of stuff shouldn't go into laws and for their account because that's just there to discriminate. It's not there for any kind of public safety purpose. The Supreme Court has rendered several landmark decisions that expand civil rights, and Congress has passed legislation that expands equality. At times, Congress and the courts are asked to determine the legitimacy of equal protection claims by various groups, as well as the majority's concern that they will be harmed by the changes sought. So there's also some people say, well, you can't give too many rights, and you can't give special protections and rights to minorities, maybe because then that maybe could hurt the majority race, basically. And so there's definitely concerns and debates around that. Is the Constitution, should it be colorblind, or should we, allow to have certain protections there for minority groups because we just need to protect those, and the majority rule won't be there to protect them. Okay, Unit 3, essential questions. To what extent do the U.S. Constitution and its amendments provide against undue government infringement on essential liberties and from invidious discrimination? How have the Supreme Court rulings defined civil rights and civil liberties? is the difference between civil liberties and civil rights? Civil liberties are basically your personal guarantees, your freedoms, your protections from government. So my freedom of speech, my right to bear arms, those are all examples of civil liberties. It's protections that I need from government because they're going to try to take away my rights. Civil rights is actually the government. It's the opposite, because civil rights is the government coming in to protect you, but specifically you being someone who's a minority, someone who's being discriminated against, basically. And so civil rights is government stepping up to protect you against, from each other, basically, from discriminatory treatment, or if I owned a business and I tried to not let you come into my store. Let me go ahead and hit present on this. Actually, I meant to do that earlier and I just forgot. So let's go ahead and hit present so we get that full screen view coming up. Okay, cool. There's the definitions again. Okay, enduring understanding, the U.S. Constitution's Bill of Rights are continually being interpreted to balance the power of government and the civil liberties of individuals. Okay, explain how the U.S. Constitution protects individual liberties and rights. So we have the Bill of Rights, and that has specific protections within it designed to protect our liberties, designed to protect our rights. There are constitutionally established guarantees, freedoms against what they call arbitrary government interference, or like if you say that word arbitrary, it just means like random, like the government trying to come into your home whenever they feel like it. That's arbitrary. You know, like if they think that I have weapons here, that like illegal weapons or drugs or something like that, that I shouldn't, then, and they have evidence of that, then it's not arbitrary. It's not random at that point. But if they just start going house to house going like, what do you have that's illegal in there? Let's just do a conductive search, you know, like the Nazis used to do and stuff like that. It's like, that's arbitrary. So unless you have some kind of evidence that I've committed a crime, or a warrant where you've presented that evidence to a judge where they say, okay, then we can go in and search that home because we think that there's, weapons in there, dead bodies, or, whatever kind of evidence of criminal activity, basically. And so that's okay. So they are allowed to come into your house and search your house, but they have to have evidence you committed a crime. It can be arbitrary, like I said. Okay, application of the Bill of Rights is continuously interpreted by the courts. So definitely like how our civil liberties and civil rights are honored or protected has changed over time. And as far as like what is okay for the police to do, what is not okay for them to do. So what are the rights protected in the Bill of Rights? So you should know all 10 of these. 3 and 7 really don't appear that often. I mean, technically they could because it's in the Constitution, so it definitely could appear. But 3 and 7, I really don't hear that often. But 1, of course, I mean, and a lot of our Supreme Court cases deal with number 1. So religion, speech, press, assembly, and petition. Basically, religion, you should have the freedom to express your religion and practice it how you see fit. And not be told how to, or not have your practices banned. So free exercise. And then also, we don't want the government establishing a religion either. So we have the establishment clause. So they don't get to establish religion, and they can't tell you can't follow yours. Second Amendment, right to bear arms. Fourth Amendment is a right, basically, no illegal search and seizure. Fifth Amendment and Sixth Amendment are like rights of the accused. Eighth Amendment, no cruel and unusual punishment. Ninth is basically like, hey, just because we wrote things down doesn't mean this is it. This isn't like an exclusive list. This is just like what the most important stuff is. But don't think just because we wrote this stuff that means that's all that we get. We get more. And then the 10th Amendment is important for the states. That's really important to federalism, that kind of concept, because basically it says, hey, anything not told that we couldn't, given to the federal government or told that the states can't do, everything else, it's up for grabs. So that's all their reserved powers. Okay, so First and Second Amendment, reflection to individual liberty. We've got Ingle versus Vitale. That's the Establishment Clause case. That's no prayer in school because they said that having required prayer in school amounted to establishing a religion. So no good. Wisconsin v. Yoder, the Yoders were the Amish family, and they didn't want their kids in school past 8th grade just because they said it conflicted with their religious values. And Wisconsin had a law that said they had to go to school, and so they sued and won. Because the court said basically going after 8th grade, telling them to attend school if they've got religious practices or stuff that they want to do or religious teachings, homeschooling in their community and that kind of stuff. That's okay. That's not a threat to public safety, basically. Tinker versus Des Moines School District. Basically, this is a free speech case. The kids who wore the black armbands to school, and they basically said that was freedom of speech and freedom of expression, and that students actually do have that in school, as long as it's not disruptive. So there's a limit on that for sure. Shank. Okay, so Shank is a clear and present danger case. So it's also political speech. So this is a free speech case, basically saying that you can, I mean, this is basically an example of them restricting free speech, an example of like why. And in this case, it was like public safety. And like, I personally, I know my personal thoughts don't matter, but I like to share them sometimes. So personally, I'm like, what he was doing was not a threat to public safety. He was like passing out pamphlets and that kinds of stuff. Think about it though. What if like we had an example today of like someone going around and spreading out like medical misinformation or something like that? Could we restrict that? Could we put, restrictions, or could we punish someone for spreading lies about, medical misinformation that could be a threat to public health and stuff like that? And would that be okay? I think likely in these times, the courts would probably uphold those kinds of restrictions for sure. Again, usually erring on the side of like public safety and that kinds of stuff. Okay, New York Times versus United States. That's a free press case, basically that there's a heavy presumption against prior restraint. So papers, print what you want to. We can punish you afterwards if you're printing false stuff or fake stuff or that kinds of stuff. You can get in trouble. So you definitely want to make sure that you're you put in a good faith effort in what you're printing out there, basically. But that you don't have to. We're not going to have the government be limiting or censoring that, because they tried to censor what they were printing out there about the Vietnam War. Okay, McDonald v. Chicago, that's the Second Amendment. McDonald was this old guy who just wanted a gun, and Chicago had basically an effective handgun ban, and he wasn't able to get one. And he's like, but the criminals are getting them, and shouldn't I? And for protection. And the court said, okay, yeah. And so they selectively incorporated that right and said, okay, now states, you can't take away the Second Amendment rights, because before they could. Okay, explain how the Supreme Court has attempted to balance claims of individual freedom with laws and enforcement procedures that promote public safety and order. So again, it's a balance. You think about, gun control versus gun rights. Is it okay for me to own a high-powered weapon with, 500 rounds of ammunition, or should there be restrictions on that? Is it okay for me to own a handgun? Is it not? That kind of stuff. And that's all opinion stuff for sure. And your ideology will help to dictate that. But that's the idea, that it is a balance. And especially also in the Second and Fourth Amendment, some people are more okay with the government being like intrusive, and they're like, I don't care if the government reads my emails if they're trying to catch terrorists, or if it's, in the interest of public safety and stuff. Other people go, it's a privacy thing. I'm not doing anything wrong, but I also don't want people like checking in my stuff and that kind of stuff. So, where's the line? And again, there's not a right answer to any of this stuff. This is all opinion. This is all stuff that evolves and changes and all that kinds of stuff. Okay, and during understanding, the protections of the Bill of Rights have been selectively incorporated. Key idea. What is selective incorporation? It's the idea that the Bill of Rights apply to the states. That's it. Just that, and then why it's called selective is because it was on a case-by-case basis, basically. It wasn't just all at once. Chunk by chunk, piece by piece, slowly but surely, and not even all of it, almost all of it. I'd say about 90 to 95% of the Bill of Rights has now been applied to the states, but still more could be applied. I think one recently, like one just like within the last year. So there's still cases that are testing and still including more and more on selective incorporation. Pretty soon it probably will be all of it. Okay, Bill of Rights originally applied only to the federal governments, but then the 14th Amendment was written, and that basically puts limits on states and what they can do. And it says, hey, states, you got to protect and honor due process. And so because of that, that's why now the states have to honor and protect the Bill of Rights. So selective incorporation, again, incorporation is applying the Bill of Rights to the states selectively because it's done piece by piece, time by time. So this is the Constitution plus the 14th Amendment, means that there's due process for the states, or due process on the states, that they have to now honor and respect due process for the citizens. So there's two cases that deal with selective incorporation that could appear there. McDonald v. Chicago is the main case for that. And honestly, to be honest, I had never heard of this case before, because it came out after I got out of college, and don't live in Chicago. So when I first saw it in the curriculum, I was like, what is this case? Why? And then I was like, oh, it's selective incorporation. That's exactly why. They wanted a case that is a great example of this, and it is. So this is like, the Chicago was a city, in this case, a local government that tried to restrict the handgun ownership, which in McDonald's mind was a violation of the Second Amendment, and Chicago was like, we don't have to follow the Second Amendment. It's not been incorporated. And then he sued, and then the Supreme Court was like, but now it is, basically. And then Gideon versus Wainwright, same thing. In federal court, you did get a lawyer. That was honored and protected. That's a Sixth Amendment right. Gideon was in state court, and they didn't have lawyers for people. They didn't offer that. And he was like, hey, we probably should. And the state was like, we don't need to. It's not been selectively incorporated. And then Gideon's like, but now it is. And the court was like, yeah, now he's right. Now we're with Gideon, basically. That's an important one, too. Explain to the extent to which states are limited on by the due process clause from infringing on individual rights. So this is basically the idea of like, when is it okay for the government to put restrictions on our rights? And in the name of public safety, that's the idea around that. So Schenck was this guy, I remember he was passing out pamphlets in World War I, and they were like, hey, we're going to arrest you because you shouldn't be passing those out, and that's going to hurt our war effort, and that creates a clear and present danger. And then he was like, wait a minute, I have First Amendment right. And the court was actually like, well, you do, but your speech is dangerous. And so it can be restricted, right? You create a danger to public safety, basically. So again, Schenck, Tinker, and New York Times versus U.S. Protections on the Fourth and Sixth Amendments. So pretrial rights of the accused. So you have rights even before you go to trial. That's important too. Like anytime you want a lawyer, you can ask for one. And it's not just at your trial you get a lawyer, because there's other things that you might need to argue and that kinds of stuff. And so you get legal counsel. They're not supposed to be searching your cell phone data and that kind of stuff without a warrant. And there's also limitations that were placed on what the government could actually collect as far as our internet searches, our history, that kinds of stuff. Okay, Miranda rule. So the Miranda rule, remember Miranda rule, the rights that you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer or have them present with you while you're questioned, blah, blah, blah. The Miranda rights came out of a case, Miranda versus Arizona, and it basically just is the court saying, hey, these are really, really important, these Fifth and Sixth Amendment rights, that we're going to make police say them to people and make sure that they understand what they are before we question them, because we want to make sure that we honor and respect the Bill of Rights. It doesn't say in the Bill of Rights, hey, police need to read this out before, right? This is something that evolved, that then the police or the courts were basically like, yeah, the police are really, taking advantage of people's lack of information and knowledge about their rights. And we should probably just, in order for protection of those rights, we should have those, spoken and basically required that people understand them before we question them and stuff like that. Okay, there's a wrap for that. Oh, and there's also a typo for that. Stated from the bottom, now we're here. We're going to have to change that. That's started from the bottom, now we're here, basically. So that was a fun one. And I do need to record the wraps for this, so I will get those, get those recorded hopefully soon. Hey, there's Drake right there. Okay. So the due process clause has been applied to guarantee the right of an attorney and protection from unreasonable searches and seizures as represented by Gideon versus Wainwright. So we get the right to an attorney. And also the exclusionary rule. Okay, what's the exclusionary rule? That's a very specific rule, but it basically is that any evidence that's illegally seized or searched cannot be used in trial. It is excluded. So I give you examples of like, what if the police searched my car illegally without my consent? They had no evidence or warrant or anything, and they found something illegal in there. Technically, they are not allowed to use that in my trial, basically. So then my lawyer can challenge that search and say, hey, wait, this evidence that they found was illegal, yes, but the way that the police found it was also illegal, so we're not going to be able to use that in court, basically. So it could help me to go free. Okay, so Roe v. Wade and right to privacy. Roe versus Wade is basically the abortion case. What should you know about it? It will not come up in the argument essay. I can almost 100% guarantee that, because it would just go all kinds of wrong as far as ideologically diverse opinions and that kinds of stuff, and emotions around this issue and stuff. So yeah, probably will not appear in the argument essay is my guess. What should you know about it? You should just know that the right to abortion comes out of a right to privacy, basically, that just says that you should have a right to privacy, meaning that you should have the right to access this, and the government or the state should not restrict that activity. They don't need to, essentially. Enduring understanding, the 14th Amendment Equal Protection Clause, as well as other constitutional provisions, have often been used to support the advancement of equality. So 14th Amendment is also important prior, because of due process on the states and selective incorporations, it's also important because it has equal protection. This 14th Amendment is freaking awesome. Okay, so equal protection under the laws and requires states to treat all citizens equally. I mean, the reason why my marriage is, protected right now by the federal government and recognized in every state is because of the 14th Amendment, because it would not be treating me equally if my state was allowed to stop me from getting married, basically. whether I live in California or Texas. Okay, explain how constitutional provisions have supported and motivated social movements. Just that, these social movements likely would have happened anyways, in my opinion, but just that they get their basis from the Constitution, and they get their basis from the idea of like people rising up and saying, this isn't okay anymore. And why do we have this law still? Or why do we have this discrimination practice still? Or why is this institutionalized, this, thing that is just negative and just hurts people and keeps people down and oppressed and stuff like that. So letter from a Birmingham jail is one of our foundational documents. So it could be used as an evidence piece for sure if the question is around social movements, or if it's about civil rights or something like that. You could use that as an evidence piece for sure. And that basically is just Martin Luther King explaining like, hey, we're justified both from the 14th Amendment and what the Constitution says, but just also what's moral and just and right. And the laws that the government is passing now are not correct, or they're not just, so we shouldn't allow them to exist, essentially. Okay. Public policy promoting civil rights is influenced by citizen-state interactions and constitutional interpretations over time, for sure. Just the idea that, some of the states were not trying to provide equality, and the federal government had to start stepping in, specifically the South. I'm calling you out, Southern states. They were basically like, yeah, we don't want to protect, rights of the minorities. And the federal government finally had to be like, okay, you need to now. We're going to step in and start doing it, and we'll send troops down there if we got to enforce this stuff. So explain how the government has responded to social movements. A lot of times it's just led to better laws, or maybe more responsive Supreme Court rulings that better reflect equality and trying to root out discrimination and that kind of stuff. So Brown v. Board, we should know, that's basically what said no more segregation in schools. So that's landmark. Civil Rights Act of 1964 both protected women and where it's intended for people of color. And Title IX of the Education Amendments Act, that's what says that now we got to fund girls and boys sports equally. Voting Rights Act of 1965, that was basically trying to break down a lot of those barriers to voting, those structural barriers to voting. Okay, key civil rights legislation. So again, these could just be used as evidence pieces, so you don't need to memorize these, but if you were thinking of like, oh, I remember there was this law about this, or there was this thing, here's just where you can find this. But Civil Rights Act of 1964, I just talked about, same with Voting Rights Act, same with Title IX. This is something that's not specifically in the curriculum, but it's a great example of civil rights for disabled people. This was the Americans with Disability Act. It's also a good example in federalism too, because this is a federal law that put restrictions and mandates on the states, basically saying you need to make your buildings compliant for all of these people that, we need to have handicap stalls and handicap spaces, and we need to go ahead and give better protections for this group that is a minority for sure and needs more special protections and stuff. So. Awesome. Okay. So I think that is, oh no, we got to keep going. Okay. Explain how the Supreme Court has at times allowed the restriction of civil rights of minority groups and other times protected those rights. So, I just had a thought right here, and this is a great example of a possible argumented essay. I just had the epiphany right here. Because this is a great example of like, here's the times that they've honored, here's the times that they have not, or here's the times they've protected, here's the times they've restricted. I don't know. I even know how you would put it into an argument essay, but that's a possibility. So just that it could totally be wrong, but just had a thought that that's they like the either or kind of thing with that. Anyways, so what's an example of a time that they have restricted rights? Plessy Ferguson. Hello, basically separate but equal. That's restricting rights because that's saying we can have segregation and stuff. And then other times, Brown versus Board of Education, they've protected minority rights. So in Plessy, they're like basically restricting rights and saying we're allowed to have segregation. In Brown, they're like, no, we're going to protect the minority rights and say no segregation. And then, also in the Shaw v. Reno, the majority minority districting. So in that case, they were trying to create a district that was majority black. And they said, no, that's not okay because we should have a colorblind constitution. And that's different. Judges have different interpretations on that. Some justices have said it's okay to have special protections for minorities because of the institutional oppressions that have happened over time. So it's okay to have affirmative action. It's okay to have programs to help, groups that have been oppressed for a long period of time. Other people say, no, that's continuing the cycle of discrimination and we should just go to colorblind and we should just hit the reset button and that kind of stuff. So that's a total opinion thing for sure on that. It just depends on your judicial philosophy. Okay, there. And now we're finally done. Okay, guys. So I love you all. Here's the source if you want to check out the curriculum and all that kinds of stuff. But I have poured through that curriculum and I've totally condensed it into this. So this is a really great resource. I hope you enjoyed this video or watched it or whatever. But I had a lot of fun making it for sure. So if you have questions, specifics, I'm going to keep working on resources. If you have suggestions or tips for me, things you'd like to see, stuff you'd like to do, just let me know. All right. Have a great day, guys. Keep studying, keep staying focused. AP test coming up soon, and you definitely want to keep preparing.